Okay, let's dive right into this explainer. Today, we're unpacking a landmark 1913 case that literally defines how we understand contracts today. If you've ever wondered exactly when a promise becomes legally binding, the story of Lalman Shukla versus Gauri Dutt is the absolute foundational bedrock. We're going to look at how a simple search for a missing person turned into a massive legal battle that shaped the Indian Contract Act in ways that still impact us right now. We've got a lot of ground to cover. First, the missing nephew search. Then, the legal dispute, applying the Indian Contract Act, the court's final judgment, contrasting this with the famous Carlill case, and finally, the core requirements for valid contracts. Section 1. The missing nephew search. The chronology here is everything. So we have this businessman, Gauri Dutt, whose nephew tragically goes missing. On day 1, Dutt sends his servant, Lalman Shukla, to go search for the boy, promising to just cover his travel expenses. Now, fast forward to day 2. While Lalman is already miles away looking for the kid, Dutt issues handbills to the general public, announcing a huge reward for his safe return. But because Lalman is out searching, he has absolutely no idea these flyers exist. Day 3, Lalman successfully finds the boy, brings him home. And it's only on day 4, well after the fact, that Lalman finally sees the handbills, discovers the reward, and tries to claim it. And the stakes were high. 501 rupees was a massive sum in 1913. We're not talking about a token of gratitude here. This was a small fortune. Naturally, Lalman felt he did the work, achieved the exact result Dutt wanted, and absolutely deserved this life-changing money. But his employer flat out refused to pay. Section 2. The legal dispute. The conflict boils down to two very different perspectives. Lalman's argument is super practical. He's saying, look, I found the boy. I fulfilled the exact condition for the reward, so pay up. But Gauri Dutt relies on strict contract law. He argues that Lalman was already bound by his prior instructions to find the boy. But more importantly, Dutt argues that because Lalman had absolutely zero knowledge of the 51 rupee offer while he was actually searching, no legal contract could possibly exist between them. Put yourself in the jury box for a second. Can a person accept an offer they don't even know exists? Think about it. If someone promises to pay for a service, but you just go ahead and do that service without ever hearing the promise, did you actually agree to a contract? It's a real brain teaser. Section 3. The Indian Contract Act applied. Let's look at the actual 1872 Act to solve this. Section 2A defines a proposal, or what we usually call an offer. It happens when someone shows a willingness to do something to get another person's agreement. When Gauri Dutt printed and handed out those flyers, that was a crystal clear general offer to the public. He was signaling his willingness to pay 501 rupees to get help finding his nephew. Then we hit Section 2B, which covers acceptance. A proposal is accepted when the person it's made to signifies their assent, meaning they actively agree to it. But this is exactly where Lalman runs into a brick wall. Without knowledge of the proposal, there can be no assent. I mean, how can you agree to a deal if you literally don't know it's on the table? You can't. And without that valid acceptance, we simply can't reach Section 2H to form an enforceable contract. A contract is basically a chain. You need the offer, you need the acceptance, and together they create the agreement. If the acceptance link is completely broken because Lalman didn't know about the reward, the entire chain falls apart. Section 4. The court's final judgment. So, the Allahabad High Court hears all of this. The gavel bangs, and they side with the businessman Gauri Dutt. They ruled that because Lalman did not know about the reward when he found the boy, he could not have legally accepted the offer. Lalman got his travel expenses covered, just like they agreed on day 1, but he didn't see a single rupee of the 501 reward. The court's logic was totally airtight. You just can't accidentally accept a contract. Their core rationale, the golden rule you absolutely need for your exams, was this. There can be no acceptance without knowledge of the offer. Let that sink in for a moment. This single sentence is exactly why law students, well over a century later, are still poring over this case. It established once and for all that doing the action isn't enough. You have to do it intentionally in response to an offer. Section 5. Carlill versus Lalman Shukla. To really lock this concept in, let's contrast it with another heavy hitter, involving a general offer. Carlill versus Carbolic Smokeball Company. Both of these cases featured a general offer to the public. In Carlill, a company offered a reward to anyone who caught the flu after using their product. Mrs. Carlill saw the ad, bought the product, got sick, and claimed her reward. The huge difference? Knowledge. Mrs. Carlill knew about the reward before she met the conditions, so her acceptance was valid, a contract was formed, and she got paid. Lalman performed the conditions totally blind to the reward. His acceptance was invalid, no contract, no money. It all hinges on that one absolute necessity: prior knowledge. Section 6. Requirements for valid contracts. Let's wrap up this explainer with the absolute key takeaways from 1913. Number 1, knowledge of an offer is a non-negotiable prerequisite. You simply cannot accept something unknowingly. The person receiving the offer has to know about it and act intentionally because of it. A general offer, like a lost dog poster, only becomes legally binding when the conditions are met by someone who actually knows about the reward while they're doing it. Bottom line, a valid contract requires both a known offer and an intentional acceptance. Which brings us to a pretty massive question for today. When you click I agree on a digital terms of service without reading a single word of it, do you truly have knowledge of the offer to form a valid contract? Think about how this 1913 ruling applies to your life right now. You might not be hunting for a missing nephew for 501 rupees, but you enter into contracts every single day. If the law requires actual knowledge of an offer to accept it, does blindly scrolling past 50 pages of legal jargon really count? It's a fascinating modern twist on a century-old precedent. Definitely keep that in mind and never, ever stop questioning the fine print.